the Conservation Commission was given some more powers, and things got better. And even though we have an awful lot of work to do, and there's a lot of backsliding going on, things have been worse in this state. There's my optimism again. Well, one of the most important tool we have that citizens can use to fulfill this optimism is the public trust idea, or the public trust doctrine. And I want to talk a little bit about the history of that. The public trust idea is that the waters of Wisconsin, the waters of Wisconsin are held in trust by the state for the benefit of the beneficiaries of the trust, you and I. We are the beneficial owners of the waters of Wisconsin. Think about that. We own the waters of Wisconsin. The DNR and the state legislature are the trustees whose job it is to manage the waters of Wisconsin for our benefit. Okay. The second important thing is about this is that we, as beneficiaries, have standing to enforce the provisions of the trust. It's up to us. We've had a number of examples in the history of our state where this power to enforce the trust has been critical. And in every case, individual people have come to the fore and spent their time and treasure in protecting the water that belongs to all of us. I just want to think through a short list of people and actions that I'm talking about. The first one is back in 1898. A guy by the name of Frank Wesley Wade, who I found out was a farmer, a logger, and an avid fisherman, of course. Frank Wade liked to fish the Willow River up in St. Croix County. An outfit called the Willow River Club bought the land on both sides of the Willow River, and then they said, this belongs to us now, and you can't fish there. Frank Wade said, oh no, I've been fishing this river for quite a while, but I'm going to keep doing it. So he did it. He got fined $20 for trespass. And so then in the good old days, he was able to take that case to the Supreme Court on his $20 fine. And the better news is that he won. And along the way, the Wisconsin Supreme Court, in its opinion, had some terrific language, in something like this. The owners of the stream banks do not own the drops of water in the stream any more than they own the air over their land. Nor do they own the fish any more than they own the birds that fly. That belongs to the people, all of the people. The second case I want to talk a little bit about is a case that involves a man by the name of Husting. Paul Husting, State Senator Paul Husting, who liked to hunt ducks in a little place in the Horicon Marsh. I didn't realize it was Horicon Marsh until because the case says Rock River, and but I finally found out with my extensive research that it's a little place in the Horicon Marsh where he was able to pole his boat into the reeds and was shooting ducks. Unfortunately, or at least fortunately for us in the long term, but in the short term, unfortunately for him, he got arrested because the land, the area was allegedly owned by the Diana Hunting Club, and they kept people from. So again, he got in trouble, litigated it to the Supreme Court. This was in 1914, the court held that this was navigable waters. One of the public rights in navigable waters is hunting. The water, even though it was only 6 inches to a foot deep, was enough to float the skiff that he came in on. That makes it navigable, and he had a right to hunt. And so his prosecution was unsuccessful. Third one, and this is one I have spent untold hours thinking about and actually reading, because it's a long opinion, but it's Minch versus Public Service Commission. And this is a case that involved dams on the Nemacoggin River. Why did I stumble on Nemacoggin? That's inches away from our place up north. Anyway, the Nemacoggin River was being dammed as a result of a county board law, it was called, that said if the county board approved a dam on a navigable stream, that was the final word. Minch held that the Public Trust Doctrine protected the navigability of the stream, and the permit for the dam was revoked because, in part, because it was a local decision, which in the Public Trust Doctrine it cannot be administered on a local level. So anyway, and the lawyer, the people who were involved in that, it's another individual, Virgil Minch, an Algoma lawyer, the Isaac Walden League, and the Conservation Commission. This is a key fact. The litigants were those included the Conservation Commission, represented by Assistant Attorney General Roy Tulane. So the Conservation Commission was litigating to protect the public trust. Some years later, in 1960, this was a 1952 case. In 1967, there was the Kellett Reorganization Commission was appointed by Governor Warren Knowles to reorganize state government in practically the whole of it. And one of the things that the Kellett Commission did was to reorganize natural resource management by combining all of the natural resource organizations in agencies, including the Department of Resource Development, merging with the Conservation Commission and the Public Service Commission water powers to put them all under one head. And during the negotiations over this legislation, one of my heroes and law professors, who's a member of the Wisconsin Conservation Hall of Fame, but that was only a small part of what he deserved, Jake Boisher. had this idea about how can we have a voice for the public when the traditional voice of the public, the Conservation Commission, is gone, sucked up into this huge bureaucracy. What do we do? Jake said, you know, I've been thinking about something for quite a while. How about a public intervenor? And so, and the net result was that the law was amended to include the Office of Public Intervenor, charged with protecting public rights in water and other natural resources, so that there would be some voice for the public to protect public rights and natural resources. And the important point, one of the important points there is, we as individuals are fully empowered to litigate, to stand up for the public trust. But what are we going to do as single individuals? We need to band together. We need representation. We need resources. And that's what the Public Intervenor's Office was to provide, as it did. As Jodi knows, they not only had the lawyers, one of whom is in the audience today, Tom Dawson. Thanks, Tom. You did good. And it also had access to resources like expert testimony and what we used to call the case account in the old Justice Department, where we had a sum sufficient, it was called, to hire the experts that we might need in litigation.